Hi, good afternoon, everyone. This is Rajiv S. Khanna from immigration.com, the losses of Rajiv S. Khanna, PC. This is our bi weekly community conference call every other Thursday. Um, what people do is they post their questions on the forums, and we will first answer all the questions posted there, then take all the follow up questions on the posted questions, and then take new questions. Now, I have enough time today. I have budgeted enough time today. If you have new questions, I should be able to take them. So don't worry about that because somebody was trying to post a question and they couldn't. So they had requested a way of posting it, and I told them that we'll make time, we'll make sure everybody's questions get answered. Okay, that said, let's begin first with Sunil K, who has posted his question. Perm filed with employer A. The initial I-140 decision got delayed. Then um, they took a copy of the same labor cert and decided to refile I-140 on the same labor certification. So we've got now two approvals on one case, which is very odd. By then, you've taken the decision to switch the jobs. The second employer filed a perm and I-140 as a future employment, which got also approved. So I shifted the job to employer B in July 2013, thinking that I can port my priority date. But employer A withdrew the I-140, but there is still one priority date remaining because the I-140 that was approved, there were two of them. One of them was withdrawn, but not both. So can I still port the priority date? And the answer is probably not. Um, here is the issue that I feel could be a problem for you. See, the you have two I-140 approvals on the same labor cert. That's probably not legal. Okay, that appears to be an error made by the United States Immigration Services (USCIS). I would not hold my breath. I think it'll be a tough case for you to make that you can keep your priority date. Um, you can try, you might be able to make it, but it's such a flimsy basis on which you are trying to build your green card. Remember one thing, biggest problem with green card is even if they approve my green card, within 5 years after the 485 approval, they can pretty much revoke my green card with one notice. So if this error is discovered, this problem is discovered, they could come back and revoke your green card. I would assume that that priority date is gone. Okay. Um, I'm going to run through the questions. I usually, when I have a little bit more time, I like to discuss each question in detail and ask people to come. And but today, let's just do it a little bit more efficient this way. Ramki apparently was represented, or his employer was represented by our firm, and somewhere along the line, the I-140 was denied. And he was trying to do an H1 transfer, and because the I-140 was denied, he he could not get his H1 transferred. There's no basis to go beyond 6 years if the I-140 doesn't exist. See, first of all, you should be talking with me separately in a one-on-one call. You are a client of the firm. All you have to do is send an email to your case manager. They'll set you up unless you ask me any questions that are creating a conflict between your employer and you. And what you're asking me does not appear to create such a conflict. Remember one thing: in order for your H1 to be uh, approved beyond 6 years, and if you are basing it upon the I-140, either the I-140 has to be appealed. Let me rephrase that. Either it has to be approved, or if it is denied, a timely appeal must be filed, not an MTR. MTR does not help you, but an appeal would. Okay. But the problem is there is only a 30-day period within which you must file the appeal. And it's not your appeal, it's your employer's appeal. Now, we've had a situation where we have filed appeals on behalf of the employees. I filed about 7 of these appeals a few years ago, and we made it clear to the Administrative Appeals Office that the employer had gone out of business and the employees had no choice but to file the appeal. There were some criminal charges against the employer and they kind of just folded. Um, they accepted those appeals, but then after a while they started declining those appeals, saying employees have no right to file an appeal. I think that would be the way to go. Either have your employer file an appeal, and if they are not inclined to file an appeal, you can try filing it yourself, and make an argument to the Administrative Appeals Office, that the appeal should be accepted because you are the one most affected. I would suggest you send an email to your case manager and have them set up a call for you and me to talk separately. Okay. Let's see what other questions you had. I only have 5 more months left in my 1 year extension. Is it better to leave um, and work for employer B from India? And once my I-140 is approved, can I get a new H-1B extension on my current H-1B? Okay, remember one thing. To get an extension on an H-1B, you don't have to be on H-1B. That's old policy, old law. Okay, I think many, many years ago, I don't recall the exact year, USCIS changed its policy. They used to say if you want to get an H1 extension, you have to be on H1. They don't do that anymore. So if you exhausted your 5 months and then you left, in the meantime, another I-140 got approved, you can get 3 years of H1 and come back. Okay. So once again, Ramki, I would advise that you just do a one-on-one with me. Next is Lakshman Charyalu. Daughter is working in an American company. OPT is expiring in May. F1 visa is getting expired in June. What are her best options to continue? Well, she should file for an H1. If the H1 is timely filed, she will have permission to continue working till her case is decided on October 1st, whichever one comes first. So that's called gap extension. So that's obviously the right thing for her to do. The problem is if she had a STEM degree, science, technology, engineering, mathematics, if she had a STEM degree, in the earlier days, she could have tried for a 17-month STEM extension and received that. The problem is with the court ruling declining continuance of this program or continuation of this program, it has become highly uncertain where the 17-month extension is going to go. Okay, so I think gap extension is a good way to go. Make sure her company files her H1, then she can continue working. There's a frequently asked question about a J2 or a J1 with a home residency requirement. Can they convert to F1 student visa? And the answer is yes. They can't convert within the United States, but they can go outside USA, try to get an F1 stamp and come back. That does not get rid of the 2-year home residency requirement. However, remember, the 2-year home residency requirement only says this. If you have a J1 or a J2, which is subject to the 212E HRR, you cannot convert to H, L, or green card. But you can, if you want, you can change to F1, but not within the United States, as far as I remember. It does not allow change of status also. Okay, so you can always get a visa stamping done, and you can do it without the waiver. F1 does not require a waiver. Okay. However, if down the line you want to convert to H1, your J1 holding spouse either must have received a waiver or a home residency, a fulfillment of 2-year residence abroad to the home country. Okay. Next question is also a frequently asked question. This is asked quite often, that I'm going to file PERM. I have finished my degree requirements, but I don't have a certificate. Is that required? And the answer is it's not required. If you can get the school to give you a letter that says you have finished all degree requirements and you're merely waiting for formal conferral of the diploma or the degree, that's good enough. But you can't be in a situation where you've taken the exams but the results have not yet come, because who knows, you may not be able to pass one or two exams. So if you have completed all requirements, whether it's research or credits, whatever it is, if you have done those and you are merely waiting for a formal certificate, that is no problem. You can go ahead as though you've got your degree already. Now, there is another issue here, Kamli. You asked whether I can join the employer with a BS degree, and then once I get the master's degree certificate, can they start the green card process in EB2? And the answer is largely dependent upon the lawyers. Have them review it. There could be a potential legal issue, but if your degree requirements are completed and they induct you, the employer inducts you on a job that requires a master's degree or equivalent, you should be able to use that degree certificate when it comes, or even get started now. Okay, this is an issue to discuss with your lawyers in detail. Another frequently asked question is about correcting dates on I-94. This is a recurring issue. So first I want to address the problem and the possible solutions or the lack of solutions. Oftentimes, we have a case that we are working on right now actually. This lady entered the US on an H4 visa, which was good for, let's say, till 2017. But her passport was expiring in 2016 or 2015. So she comes in, Customs and Border Protection gives her an I-94 only till the date of her passport approval. Okay. And sometimes they do that, they give it only to the extent of your visa approval, which is incorrect. Your visa could be expiring earlier than your approval. They should still give you the I-94 all the way to your approval, not to your visa. In this case, they gave it only till 2015. And she's been here now over a year in unlawful presence, not realizing that she had been given less stay than 2017. So this is a very, very complicated issue, and it's a problematic issue. They will correct mistakes that they have made. If they have made a mistake giving you the wrong date or giving you the date till visa, not the approval date, you can actually go back to CBP at the airport or at any of their offices, any of their posts. They have a list of them on the cbp.gov website, and you can ask your I-94 to be corrected. But there are certain things they don't consider them to be errors, such as what I've just mentioned, approval till the passport expiration. That cannot be corrected. So the question is, what do you do there? You have two choices. Either you can do an extension of status or extension of your current status by filing Form I-539 or 129 if you are an H1L1 holder. For H1L1, that's like doing a new case all over again. H4 is relatively uncomplicated, it's simple. Or you can step outside USA and showing your visa, come back and receive your I-94 approval. But if your I-94 has already expired, you must speak with a lawyer before you leave. You could very well be subject to the bar which comes from being unlawfully present. Okay. So in this case, what happened with the Perry Putter, he traveled, or she traveled, I guess it's he, traveled to India while change of status for H1 was pending. From H1 to H4 was pending. Okay. Now, USCIS should have declined the H4 change of status because they left the US. Came back, received an I-94 good till December 2016. The visa expiration date is November 2016, which is what I gave at the airport, he said. What action would I be required to correct the I-94 expiration date? Look, you can go back to CBP and make your case that you have made an error. I don't see the error. If anything, they've given you more time, not less. And because you traveled abroad while your change of status was pending, that approval is really not worth anything. That's a mistaken approval. I am filing for a 485 adjustment as a spouse of EB3. Is it okay to use the more conservative November 25 date? I would use the date that they have given on your I-94, and I would attach an explanation saying that this date may be incorrect, but you don't know. According to your calculation, it should have been November 25th, 2016. Okay. I always like to make full disclosure to the government so that they don't come back and create a problem with the discrepancy. Next question is Vijay Anand, H1B petition selected and approved during 2015. Now there's a change in citizenship. I'm a citizen of Finland and I want to renounce my Indian citizenship. Do I have to do an amendment of the H1B? To the best of my knowledge, no. But you should double check that by calling the USCIS customer service. Make a note of the answer they give you. I see no reason to do an amendment. There is no change in the job, no change in the job location. It's a change in your citizenship, which is not a material change, at least in my mind. Okay. Can I use the approval notice of the H1 to appear for visa in Finland? Yes, you can. If an amendment is to be filed, how long this typically takes, you can file an amendment premium processing. But an amendment, in my view, should not be required. Okay, double check that with the customer service, USCIS customer service. Kumar, which is immigrant 2015, says I switched from employer A to B last year under AC 21. I have an approved I-140 and 485 pending with priority date of 2009. When I switched, I justified that both my jobs are same or similar. Employer B has also filed a new labor, which also got approved. So we've got old labor, AC21 done, and a new labor. Since I already have an I-140 and 485 pending for employer A, do we need to file I-140, 485? I think you should interfile your I-140 on top of the 485. Let me think about it. You've done AC21. You can interfile. You could also take the argument. You should take your lawyer's help in deciding whether the jobs are same or similar, and the same AC21 can cover your job. You could probably do an AC21 letter again covering the new I-140 job. Don't use that I-140, but file an AC21 saying it's the same job. I think that will help you retain your priority date better than if you interfiled the I-140. Somehow, I haven't worked out the details of it in my own head, but that appears to be the better way to go. I would have to sit down and reason it through all the way to give you a more definitive answer. But to me, it looks like an AC21 is the safer route for you. And even if you did not do an AC21, you wanted to just substitute your new I-140 over the existing one, it's called interfiling. It's not really a legal term, but we've been calling it interfiling. So if you have an I-140 and 485 pending, new I-140 comes, knocks off the old I-140, and sits itself on top of the existing 485. Okay. Gaurav Sharma has a question. If I'm in family base 2 category, if my father applies for citizenship, it's actually less advantageous for them. Their dates become more backed up. What are the it's more backlogged than a family base 2 category. What should we do? I don't know the answer off the top of my head, Gauravji. I think there was an opt-out. It's called opt-out. I don't remember if it is applicable to this category or not. It might be. Basically, what it says is if you don't want to be converted, you can send a letter to USCIS and ask to be treated as a part of the old category. Make sure it applies to you. You can do some research on that. I don't know the answer off the top of my head. Your second question is, can I visit USA while my green card is going on? I know a lot of people who were able to. And I know also a lot of people who were denied. So there's no harm in trying as long as you tell the truth. You don't try to lie to the government that your green card is not pending. So if you tell the truth, they may or may not give you the visa, but it should not cause you any harm in your green card application. Okay. There's another frequently asked question: travel while H1 extension is pending, change in I-94 number. Folks, if I file for my H1 extension, okay, I'm allowed to travel. I'm allowed to travel even when my H1 transfer is pending. Okay, there are some things to keep in mind when you do it, such as are you maintaining status, etc., etc. But travel while transfer or extension of an H1 is pending is allowed. The question is, when I come back, my I-94 changes. That is not a problem. That should not cause any delay. And I don't see any need for any amendment. We have never done it. I don't anticipate this to be an issue. The fact that your H1 is taking so long is most probably not related to this issue, that you have a new I-94 number. But if you want, you can double check with the USCIS customer service. I always advise that anyway. Next question is a little bit complicated, and I'm going to try to parse it through. There's a lot of issues here from Hemant. Let me just move over, see if I can address these issues. I'm on L1B since March 2011. Visa renewed to Jan 2017. That does not make any sense. Unless you entered USA late, L1B is maximum 5 years. So there's something wrong right there. My employer, or unless you traveled outside for almost a year or so. Otherwise, this doesn't make sense. Employer filed for perm in June 2015. Son is turning 21 in December 2015. As my son cannot be on L2 after 21, we have actually done F1s for these situations. We have done F1s. When a child is becoming an adult, they can no longer be on your derivative. We have done F1s. I don't see any problem with that. What does duration of status mean? DS is typically an endorsement on the I-94 on F1s and J1s, which basically says your status does not end on a particular date. Your status does not end on a particular date. Like if you come on a B visa, they stamp it valid from this date to that date, and on that date it expires. But for students, because it can take variable amount of time to finish your course, they give you an I-94 that says DS. Will he be protected by CSPA? Well, the CSPA law is like this. The time during which the I-140 or I-130 is pending is taken out of the person's age. And if they are below 21 and you file immediately upon the priority dates becoming current, they are protected by CSPA once the 485 is filed. Okay, so that's the way it works. Yeah, whatever time the I-140 was pending, that time is counted out, and once 485 is filed, I didn't think about this issue. What if I-140 and 485 are filed concurrently? In March 2016, but he's already turned 21, right? I don't know how CSPA applies in that case. I'll have to look that up. So the issue is, he's turned 21. Then I file the I-140. I think CSPA does not protect him, but don't take my word for it. I would have to look at the law very, very carefully. Because normally what happens is, the cases that we see all the time is I-140 isn't approved, and we are about to file 485, and that's when we take out. I don't know. I'm confused. I would have to look up the law, see what the government has said about this issue. Can we or can we not count out I-140 time? But how would that help? Just applying common sense. So let's say January 1st, I turned 21. Okay. February 1st, you apply for I-140 for 85. I-140 stays pending for 2 months. You can take 2 months out of my age, but by that time I'm 3 months over 21. So really that situation, I don't see how, that's just common sense. CSPA would not protect. I don't see how that would protect you. That's the way I see it. So because the time keeps moving, the time that the I-140 was pending, the fact is your son's age is also moving. So the time, if he's over 21 by the time I-140 is filed, I think he's out of luck. If I-140 is filed before he turns 21, and then the I-140 gets approved, there's a potential for CSPA to help you. Next question, wife and daughter's L2 is being extended. Generally speaking, again, there are too many facts here. Generally speaking, I-539 and 765 can be filed concurrently. My wife has an EAD card with the same end date, December 30th, 2015. Generally speaking, again, I'm confused about what your question is. Generally speaking, you can, of course, file I-539 extensions or change of status along with the 765. I hope you're on the phone because I'm not sure you've made this clear, or maybe I'm not understanding it. Next question is, driving license of your wife has the same date as the I-94. I don't know what the Department of Motor Vehicles does. This is a state level issue and it's different in different states. And normally they are very unreasonable because they don't understand immigration law. Okay. For an issue of driver's license, I advise people to contact your state legislator, not congressman, but local state legislators, see if they can help you out. Next question is from Jeet, who says what happened with him was his wife came on L2 and she got an annotation on her visa that says clearance received because she was working in the avionics industry. Well, what happens is if there is any weapon grade technology that your wife is working with, government seeks certain clearances from the State Department. I think they're called Visa Mantis, Visa Donkey. There are different kinds of clearances. So the question number one, can she use Dropbox? No idea. Send an email to the consulate. Dropbox are local issue, very sharply confined to their local policies. I would also go and look it up at their website and see what they say. Again, can I use the Dropbox? Please check with the consulate. I do not know the answer off the top of my head. My employer A is filing green card for me, though I am on L1A, they are filing EB2. The reason I came to USA on L1B as technical. I've looked at your situation. You were a supervisor, and it may be possible. This is something I have to get into more detail. See, sometimes people arrive in the United States on an L1B, but their job in India or wherever they are coming from was managerial job. In those cases, you can still file EB1C, although you are on L1B yourself. Okay. Now, another question is, can EB1 be filed only within 3 years of coming to the US? There's an exception in the law. Have your lawyers look it up. So normally, when I want to file an L1, let's say you come to USA on H1, okay, and you have worked for this company for 5 years, and then you come to USA and you have been here for 4 years on H1, can you file an L1? because the last 3 years you've been here? And the answer is yes, if your H1B is for a branch of the same company or a sister or a daughter or a mother or an affiliate of the same company for whom you were working. So there's an exception of the 3 year rule for those people who are working for the same group of companies as they were. So instead of taking 3 years from the date of application, we go back to 3 years from the date of entry into the United States. There's an exception to that. See how that applies to your case. I don't recall whether it applies to EB1. I know it applies to L1A for sure. And I remember, I think we did a case out of Canada for that, where that issue came up, and indeed, that gentleman was on TN, if I remember correctly, and we were able to get the green card. Memory doesn't serve me very well exactly what the issues were, but I think we were able to get the green card, taking recourse to the regulation that counts 3 years from the date of entry. Question number 4, if they file EB2, I have only 2 years remaining on L1A, you should convert to H1. Then you can extend H1. Okay. If I leave next year and be in India for 1 year and come back on L1A, can I convert EB2 to EB1? Yes. Yes, you can. You don't convert it, you basically file EB1. Yeah, absolutely. Is there any condition like L1A should be valid for at least 6 months to enter the US? No, no. You should be okay. Remember, if you are outside USA for 1 year, your 7 years of L1 get reset anyway. So you have, when you come back, you don't need the remaining L1 that you have. You have 7 more years. Okay. This is another frequently asked question. So I'm changing employers. What immigration documents should I keep? Well, first of all, I think it is always a smart idea to have a complete copy of your file so that you know what has been filed on your behalf. If you can't do that, at the very least, have copies. You don't need originals. Have copies of all your approval notices and at least a copy of your labor certification if you have filed the PERM. Copy of H1 approval, copy of I-140 approval, and copy of your PERM. That's what I would recommend, Rahulji. Okay. Next question is BSAC pending 485 EB3 2005 priority date. So he is going to file 485 for the family. Okay. All right. So I'm assuming you filed your case in 2007. Was it 2007 all the dates became current? So, but for dependents, you're filing now. And for filing a dependent's case, is an employer letter needed? Not directly. I don't see any need for that, but I do recommend you get a lawyer, please, to do this. Although 485s are not complicated, they are document intensive. So yeah, but directly you don't need a letter. But if you're filing an I-864 affidavit of support, you would be required to back that up with an employment letter. But you don't need it for your wife. Should I provide employer letter with the new position and a copy of my AC-21 notification? You're not required to. None of that is required. Okay. H1B masters say my current employer is applying for my green card. Minimum skills, 3 years of experience and a master's degree. I have the experience, I have the master's in CS, but I acquired a couple of the technical skills in my current job. You can't use those skills. Not unless the job is more than 50% different from what you did to what you would be doing under the green card. Okay. All my jobs have been in the IT field in non-managerial roles with just change in job titles. But the companies I have worked with are in different domains. One is IT services, for example, one is technology company. Here's another problem that I'm kind of noticing that might be an issue for you. See, let's say um, two situations. Let's take the example of IBM. I am an employee. I'm working for IBM as an employee. I cannot use any of the experience I have gained while I am working for IBM unless the future job they are offering me or the job that they are offering me for green card is more than 50% different from what I was doing for them earlier. This situation is also true if I'm working at IBM as a contractor through a third company. So even if I'm working as a contractor, I've got to have more than 50% different job if IBM is filing my green card. Okay. So I hope that answers your question. Domain difference does not matter. 50% difference has to be with the same employer. The previous jobs don't have to be 50% different. So before IBM, if you worked for Sun Microsystems with exactly the same job, you can use that experience. When you're applying through IBM, you can use experience through Sun Microsystems, Microsoft, or any other company, as long as it is not IBM. And the jobs don't have to be more than 50% different. I hope that explains it a little better. Neil, I am on my second H-1B extension, valid till 2018. First one was approved for 2 years. Started my green card process, filed PERM. Can I file I-140 and 485? Currently, my wife's country of birth is Panama, but she's under DACA. I think this question has been asked of me before, and from what I could remember, for cross-chargeability, I don't think she needs to be eligible to file 485 herself. Could be wrong. I'm not sure this is the right answer. It's a fairly interesting issue. So normally, if she was in good status, she was on H4, you could, I'm sorry, somebody just tweeted. I want to make sure it's not one of you guys. Okay, no. I normally follow my Twitter account at the same time if somebody's tweeting to me. So if she was on H4 and she's Panama born, I can use her country of birth to file my I-140 485 and not use India or China, wherever I was born. But what if she's unlawfully present and she's subject to 3-year or 10-year bar? I think you can still use cross-chargeability. But this needs to be followed up, Neil. I'm sorry, I don't know the answer for sure off the top of my head. Didi has got married and wife got temporary green card. He came to know that she got married only for getting a green card. Can I withdraw the I-130? You cannot. You cannot. But you can certainly send a letter to the USCIS if you believe this to be fraud. And if you have not committed any fraud, then why should you worry? I suggest you talk with a lawyer, get their advice, and remember, she can get her green card, permanent green card, she can get her condition removed, even if you don't participate, as long as she can prove that the marriage, when it was entered into in good faith. Okay, so just remember that. Next question is about family medical leave. Maternity leave is a frequently asked question. How much medical leave is allowed? I remember looking at this issue up a few weeks ago, and I thought if you just Google FMLA, Family and Medical Leave Act, FMLA, Family and Medical Leave Act, you come up to the Department of Labor website that explains the law to you, that you can go 12 weeks easily, and USCIS will honor that. They'll still consider you to be in status. So even if you don't get paid for that time and you don't get a pay stub, that's fine. Now, if there is a medical reason, for example, a pediatrician saying she needs to have X number of months of leave, I think she'll be in status. I often quote this example. We had a case where one of our friends had to be hospitalized for an extended period of time, and then she was out of work on H1 for almost a year. But we were able to convert her to H4 because government realized she was not out of work because she didn't have a job. It was because she had a medical necessity. Okay. Now, 12 weeks is normal, actually. That's what I understand. Double check that. If she changes her status to H4, will her current employer have to file a new H1B or simply a change of status? Well, H1B, she's not subject to the quota if she changes to H4, but the employer will have to file an H1B change of status, which is almost like doing a new H1. Can it be filed premium processing? Yes, it can be. Okay. This is Andy. He's in US on H1B, stamping till 2016. F2A priority date is May 2014. I-130 is approved. I'll be current in the coming month. You'll file for adjustment of status. That is correct. How long would it take? Typically, it should be wrapped up within a year. It could be as little as 6 months. Sometimes it can, the whole process, once you file the AOS. If there's nobody can really tell you how long it's going to take. Okay. The earliest I've received approval on a green card was about 3 months, start to finish. The latest, if everything else is current, a few years because somebody got stuck in security checks. Okay. I'm traveling to India from November 5 to November 28. Would you recommend a file AOS in the first week of November? I would probably do it if you come back. But the problem is, look, if you ask my opinion, I don't like to take a chance with AOS. The way I would do it is I would postpone my India trip. I would first file my AOS, wait till I get my advance parole in hand, then travel on the advance parole. That's what I would recommend. Because the priority dates could be a problem again in December. And the last two questions, Sri Ram Kumar says, my H1B will max out. This is my last year on H1B on 8th November. Labor was filed in May 2015. So that means you become eligible for extension in May 2016. I'm planning to change my status to F2. I'm assuming that you've recaptured the time, Shriram. So my wife already got admission at the University of Harrisburg. She's got her I-20. Okay, from what I understand, I'm a little confused about what you're asking me. But let's say her change of status to F1 is pending. You can actually continue working on H1, and before your H1B expires, file for a change of status to F2, even though her application is pending. As long as you've got a receipt, you can file your F2. Last question, Gokul says, wife works for a non-profit, quota exempt. They are being acquired by a for-profit. They'll apply for the H1B in quota in April. What if the application doesn't get picked up? I don't know. I think obviously, if the character of the company has changed, they would, if she does not get picked up in the lottery, she's like anybody else who does not get picked up in the lottery. She no longer has status to work in the United States. So she'll have to look at her options just like anybody else does. Okay. Now, let's get started with follow-up questions on posted questions. No new questions. I will do the new questions after I finish this round of follow-up questions. Follow-up questions, press *5. Press *5 on your phone, please. Follow-up questions. 1, 2, *5, follow-up questions. No new questions. Only 2 raised hands so far. So I guess 3. I guess we're going to have a lot more new questions. That's okay. No problem. I made room today, make sure I answer as many as I can, and I'll try to answer everybody's questions. Let's begin in the order in which you called in. The earliest one first. So, Alabama. Alabama, go ahead, please. What is your question number? Alabama?
Rajesh, hi, this is Gokul here.
Gokulji, I just saw your question right here. So, non-profit company getting acquired by a for-profit company. What if the H1 doesn't get picked up? Yes, sir.
Yeah, so as you said, it's our condition is as good as everybody else if it doesn't get picked up. So
Yeah.
We were wondering, I mean, the reason why we chose this was because it's a quota exempt and there is a security and we don't have to go through this loop. So, is there any way we can uh, explain it, or I mean, can that be used to mitigate this um, chance issue where we may not get picked up? I don't know if I'm clear enough.
No, you are clear. What you are saying is, can we leverage the fact that we relied upon this
Yes,
being
sir.
a quota exempt H1 and now all of a sudden the rug has been jerked from under our feet? Can we leverage this fact? And the answer is probably not. Okay.
Okay.
Now, I'm not aware of any law that actually clearly lays out. In fact, I'm quite sure there's no law that quite clearly lays
Okay.
out such a takeover. But common sense or legal common sense says that you're not going to be able to do anything about it. That's my guess.
Okay. We,
Okay.
okay.
Good luck.
Okay.
Good luck,
And
Gopalji. Yeah, go
thank
ahead.
you. Thank you so
No,
much.
go ahead. You had a follow-up question? Go ahead.
I was actually going to ask a continuation question of Sriram Kumar, if that is all right. I was considering that kind of a scenario as well. Is that okay, or should I wait in line?
No. That's okay. I want to, if you're on the phone, might as well cover your question.
Okay, so if I understood correctly, Sriram Kumar was saying one of the partners who is applying for F1, the ones, and the second partner is on H1B. Once the F1 is approved, the second partner will want to
No,
apply
hang on.
for an F2.
Hang on. I think his issue is, and I could be wrong about this, from what I understood, his issue is she's filed her F1. Okay.
Right,
I am working on my H1. It's taking almost a
right,
year for them to change status to F1. In the meantime,
right.
she started attending classes, F1 is pending. I am running out of my H1. What do I do? And I
Right.
said, as long as you have a receipt of her F1 having been filed, you can use that receipt and file for F2, even though her F1 is not approved. You can file it
Right.
because it is pending.
Yes, so my question there is I was just doing random research on this issue, and I don't know how credible the information I found, but people are of the opinion that if, even though F1 receipt has been issued and if the F1 is still pending and the approval is still pending, applying for an F2, a dependent visa on that pending F1 is likely setting up for yourself for a refusal. That's the information I found. What is your take on that?
I don't understand. I would like to understand the reason for such an opinion. The only thing I can
Okay,
think of, if I put my mind to it, it's because, well, both husband and wife are here in USA and we are going for F1, F2. It looks like we intend to stay here. Hang on. How does that matter? Even otherwise, if somebody
right,
is on H1, the fact that you are together in this country exists, whether you're on F1, F2, F1, H1, F1, some other visa, it doesn't really matter. So I don't see how that in any way inhibits the grant of an F1 just because somebody has filed for an F2. Okay, Gokulji? Oh, okay, I think I lost him. All right, let me go on to the next question. This one is from the wonderful valleys of New Jersey. New Jersey, go ahead, please.
Yes, Rajesh, I have question number 19.
1 second. Let me get to your question.
sure,
Okay, give me a
sure.
moment. 19. Maternity leave? Is that the issue?
I'm sorry, traveling. So my son is getting married, so there's a way that I cannot be there.
Uh,
So you recommend that once I come back on November, in December, I should file external status.
okay, hang on. You are not 19. You're probably 20, I think.
Madam,
Yeah, you're 20. Because 19 is maternity leave. So,
Oh, I'm sorry, that's not my case.
yeah, I was quite sure you were not taking maternity leave. Somehow I had this sixth sense about it. Okay.
Yeah.
So no, the reason I say it is I am a very conservative person when it comes to immigration approaches. Okay, I can be aggressive if that's what we need to do, but my first choice is always to do the safest thing. And the safest thing
Yep.
here is I don't know what December is going to look like. Okay, so I want to have you file November 1st, file your 485. wait for your EAD and actually advanced parole. They come on the same document. Wait for it to come, then travel. Postpone your plans.
Oh, sir, the problem is not the problem, but the thing is that my sister is getting married. I don't know, I've already booked
Then you don't have a
I
choice.
have to.
Then you don't have a choice. Look, let's see. November is 31 days or no? November is 31 days, right?
30.
January, February, March, April, May, June, July, August, September, October. No, yeah, November is 30 days. So, is there any way you can prepone your coming back? Because I'm thinking, as long as you get your AOS in the hands of USCIS within the month of November, you're safe.
So does it matter if I'm in India and they fight for my adjustment of status?
You have to be.
Right,
You have to be
you can't
physically.
do that.
No, you have to be physically in the USA.
Okay.
Okay.
Right.
So-
That makes sense.
Yeah, just
I could probably find it on the 29th.
have your
On
application.
the 29th.
Have your application ready. No, have your application ready. The moment you land, let your lawyers know they can file the 485. So I would suggest you enter 1 or 2 days early if you can.
I can try that for sure.
Okay?
And yeah, should I get the medical done in advance?
Yes,
Right
yes.
now I can get it.
Yes, get your medicals done in advance. That's what I would do.
And would I need the birth certificate? Because the birth certificate definitely doesn't have a name, so I need to get affidavit and whatnot.
Let your lawyers help you with those things, but your application
Sure.
should be prepared. Even if documentation is not perfect, as long as it is there enough to do an adequate filing, do it. Deal with the RFEs later on.
Sounds good.
Okay?
Thank you. Thank you so much, Ravi.
You're welcome. Good luck. Of course, sister's marriage, you can't neglect that. Okay. Let's go to Texas. Texas, go ahead, please. Texas.
Yeah, can you hear me?
I can hear you fine. Yes, sir.
Yeah, it's question number 13.
1-3. One
And
second. One second.
In co-
One second.
1-3, yeah, and number 2.
Let's start with 13. Clearance received. Yes.
Yeah, number 2 of 13. I mean, question 2 of 13.
Okay. Question number 2. Coming to US on L1A from the same employer, I got job offer from B. Employer B filed H1B. I got IFE and denied. You never worked for employer B. Now my L1 extension is approved from same employer A. If I go to India, do I need to go for visa interview or can I use Dropbox facility? I'm sorry, I don't know the Dropbox rules because these rules are so particular to India and we have a international practice. I don't know all the rules off the top of my head. Typically, what our team does is they go and look it up and they inform you and they brief me. So I would have to look up the website myself. And these rules actually have been morphing over a period of time. So if I remember correctly, one of the requirements of the Dropbox is that your uh, your petition has never been denied, and I think that does not apply if you are applying for a visa from a different category. You're applying for an L1 visa. You're not applying for an H1B visa. So I feel like you should be able to go through the Dropbox if that is your concern. But I don't know what the real rules are. Sorry, I'm just making a guess here.
Yeah.
Okay.
They are telling like visa should not be denied. So I never went for visa.
No, visa.
My
So
petition itself is denied.
that is not a problem at all. Obviously, visa is application at the consulate. If that has never been denied, no problem. That is not stopping you from Dropbox.
Yeah.
Okay.
Because I have written the exact line from USCIS. They're telling you should have no refusal of any class of visa after
No.
most recent visa issuance.
Yeah, visa is not that is not an issue then. Because denial from USCIS is not a visa denial.
Okay.
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 Good luck.
And
Oh yeah. Go ahead.
okay, similar to the next, like it's question number 3, like when I came on L1B, that time my entire petition tells like I was a technical expert, and though I was doing all the managerial work for project lead and approval and hiring and other thing. So since if I have gone back and I have seen my L1B petition, it tells I was doing the technical work and all those things. So in that case, will it be issue if they file EB1 for me?
Gigi, we've had cases like this before. Okay. This is a very specific question that depends entirely upon what was said to the government and whether the truth actually falls within that definition. Okay. So if you define your job a certain way and truthfully the job involved more than that, you can always expand on it. But if you want to create a completely new job description, I think you're going to have a problem.
No, no, yeah, because thing is that like I have 5 6 years experience in the offshore with the same company. So yeah, I was technically expert, but definitely like I was managing the team as
Well,
well.
you
Like
can
whether
be both. You can be
we are
both.
not.
You can be both. An L1A can also be an L1B. Okay. And sometimes an L1B can also be an L1A.
Okay.
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 Good luck.
Yeah. Yeah. Thank you so much.
You're welcome. Okay. So last follow-up question is from India. India, go ahead, please. India,
Hello.
go ahead. I can hear you.
Hello, sir.
Yes, sir.
Hello, sir. My question number is 4.
1 second. 1, 2, 3, 4. Daughter is working in American company. OPT is expiring, right?
Yes, sir. Yes, yes.
Yeah, and I said to you that if you file for her H1, if her H1 is filed, she can continue working till October 1st, or when the case is decided, whichever comes first.
If he doesn't get H1 in 2016, what would be her option, sir?
That's a question I would have to write a fairly lengthy article on. I don't think I can answer that question in 2 seconds. Um, Basically, people either go back to school or they leave USA. Those are the two obvious options, unless they can qualify for some other visa like an H3, etc. But that's not a question I can answer in a brief call. It is a fairly lengthy question. Okay.
Okay, one more thing, sir. So if he wants to continue her studies there, can she apply for F1 visa from there itself, or she has to come to India and go for F1?
If she has been maintaining status, they can usually roll her service, her admission over to a new program within the US.
Okay, sir. So her visa is expiring in June 2016, sir.
It's not the visa, but the OPT that matters.
OPT also she has up to May 2016.
Yeah,
so before
so
that she can apply and apply for a study.
Right. She needs to go talk with the schools where she wants to go to school and see if they can roll her service, her admission over to a new course. Okay.
Sir, one more thing. Can she also apply H1 from 2 companies, sir?
She can apply for an H1 from 50 companies as long as they're not related to each other.
Okay. Thank you very much, sir.
You're very welcome. Good luck.
Thank you, sir.
You're welcome. Okay, it appears there's one more question from Wonderful Valleys of New Jersey. Go ahead, please, New Jersey.
Hello, Rajiv, sir. I think we missed question 19.
Oh, I did. I'm sorry. My apologies. Let me just double check. It is possible. Let's go back to 19. No, we did not. I covered that as a frequently asked question. Maternity leave on H1. I covered that in great detail. Maniji, I don't think you heard it, but you will hear it in the recording. I'll very briefly repeat it for you. This is covered by Family and Medical Leave Act. If you Google Family and Medical Leave Act maternity leave, you should come to the Department of Labor website, which should tell you that up to 12 weeks of unpaid leave is acceptable under FMLA If it is beyond that, I think the laws may be different. I am not an expert in Family and Medical Leave Act, but from an immigration perspective, 12 weeks look like they are okay, and a few more days if you need. It may be a good idea to just get either a medical certificate, but I think if it's just like a 10, 15 days extra, see, 12 weeks is what? 3 months, right? You want 4 months.
Yes.
You want 4 months.
Yes.
But if a pediatrician says that they are recommending that she take an extra month off, I think that will keep her in status. I don't see any problem with that.
Okay.
Okay. And she can get a $0 pay stub or not get a pay stub. Either way, I think it's okay. But under the law, the employer is required to continue to provide her benefits. If I remember correctly, under Family and Medical Leave Act, they have to provide benefits. Not my field. It is really a personnel law field or labor law field. But I think 4 months can be accommodated that way with a letter from the doctor recommending an extra month. She should be fine.
And then we don't need the pay stub to be in status.
I don't see what the pay stubs are gonna do. I mean, as long as the job is still open, I don't see any problem with it, Manishi.
Okay.
Okay.
One last question, Rajivji.
Mhm.
She has her H-1B amendment filed, and then she went on leave. So it is still pending with USCIS. If we choose to go for H4, will that be a problem?
I do not know, because what happens is there is a domino effect here. If you have status A, in this case amendment pending, and you apply for status B, in this case H4, if government says, look, because A was not approved, you have fallen out of status, hence B cannot be approved, it's like a domino effect. One governs the other. So definitely worth a try. And especially when you have a sympathetic case. I have a new baby. I'm not going to go to India or anywhere else. I think there's a very high likelihood you might be able to get H4 within US.
Okay. And the question 5 in the post, which is if she goes on H4, can H4 to H1B?
I answered that question also. I'll repeat it because you're going to be a daddy. You're probably confused. I normally don't repeat my answers. It's a waste of everybody's time. But the way it works is COS from H4 to H1B can be file premium processing. Okay.
So, and she would need the same only, right? The current employer will not need to file a new H1B.
When you say new H1B, I don't know what you mean. She will not be under the quota if that's what you mean.
Okay.
Okay.
Thank you so much.
Oh, you're very welcome. Good luck with the baby.
Thank you, Rajivji.
Bye-bye. Maybe I should start charging some kind of, especially from the New Jersey guys. They get excellent desserts in New Jersey. Maybe I should start charging them in desserts. What do you guys think, huh? Please don't send me any desserts. I actually give them all away because I have no control when it comes to sweet stuff. Getting back to all the new questions. Guys, anybody has any question, press *5 on your phone. New question, old question, doesn't matter. Press *5 on your phone. Anyone has any questions? I'm very surprised. Only 2 so far. That's unusual. 3. The amount of noise you guys were creating, I thought there was like 10,000 people with questions. There's only 3. Oh, there's only 2. Okay, no problem. Back to 3. All right. Let's start with the new questions. There are 3 people who have new questions. We'll start with California. You logged in the earliest. California, go ahead, please.
Good morning, Rajivji. I have a question regarding H4 and H1.
Yes,
so I'm currently on H4 and my EAD got approved. So I went to Canada for stamping. That's also done.
Okay.
And so my employer this year, I quit my job in February this year, but they still applied for my H1 because at that time I have not applied for my EAD. So, which got approved, and due to the restructuring of the company, the position is no longer available, and they want to withdraw the H1B. So I requested for the approval notice as because I wanted H1 to be a backup plan just in case something happens and the EAD I am not able to work on EAD. I wanted to safeguard my H1B. So in the meantime, the company also charged for the filing fees as a surety that I'm going to join back in October when they're going to refund my money once I join them. So I paid the entire fees to the UCSIS and the company attorney. Now the situation is that they are not ready to cooperate. They're not ready to give me my approval notice, which I was requesting. So the first question I had was, if the company withdraw the H1B, can I still apply elsewhere if I need to and be quota exempted?
And the answer is probably yes. Because we have done cases where we had no copy of the approval. We either had a receipt number, sometimes not even the receipt number, just the name of the employer, name of the employee, social security number of the employee. We were able to get quota exemption.
Okay. Even if they withdraw the H1B?
Even if they withdraw, yes, because it's after October 1st. If they withdrew before October 1st, you would not be exempt from the quota.
It got approved on September 15th.
But when did they withdraw it? When did they revoke it?
Oh, they haven't withdrawn it yet. They're giving me 2 weeks notice.
You're already exempt from the quota. I'm assuming that you got change of status, just change of status to H1, right?
So no, I'm on H4 and
No, I understand
H4,
that. No, I understand that. Let me rephrase the question, make it clear. When they filed the H1, did they file it as a change of status case or visa stamping case?
No, they filed as I think a consulate. They did not file as a change of.
Okay, then you have a problem, because USCIS position is, if you file a case as a change of status case, regardless of whether you take advantage of that or not, and the case is withdrawn after October 1st, you are exempt from the quota. But if the case is filed as a consular processing and you do not actually go and get a visa stamping, you are still subject to the quota.
Okay.
Now,
okay.
Let me also advise you something. It is illegal from 17 different angles for the employer to do what they have done. Okay? It is illegal for the employer to charge you attorney's fees. It is illegal for the employer to have you pay for the filing fees. Here's what I want you to do, and you have nothing to lose in this, because your money will be returned to you. What you do is you look up wage and hour division complaint. Department of Labor, Wage and Hour Division. They have a form, I think it's called WH40, Wage and Hour Division 40. You file that form with the government. You complain against the employer. You let them know about their practice, what they have done to you. The company will be investigated by the Department of Labor, and they will get you your money back.
Okay, yeah, that was my another question. So would it harm me in any way, because they will be like, why did you?
No, absolutely not.
Okay.
Not only will it not harm you, I will absolutely insist that you file a complaint. Companies like this should not be allowed to get away with this nonsense.
Yeah, I totally agree, because at first place they were like, okay, you have to promise you join us back, which I did. I was like, okay, I'm going to join you back. And now I've waited for like 5 years for H1B. And when I have H1B, they're not ready to cooperate. They're withdrawing my H1B and not even refunding.
Okay, hang on one more second. Not only will you get your fees that you paid them, you will also get your salary, full salary, till beginning October 1st, till the time they actually revoke the case.
Okay. But I mean, I wasn't working with them.
It doesn't
In
matter.
February, I resigned.
It doesn't matter. You go ahead and complain to the Department of Labor. You let them decide what is coming to you.
Okay. So Rajiv, offline, if I need to take your legal help, or who do I contact
You don't
regarding
need
this?
a,
Because
you
I
don't,
want
no,
someone to help me with this case.
you don't need a lawyer for this. But if you want to contact me, my email is very easy. My email is help@immigration.com.
Okay.
Okay?
Yeah, because I don't want to take everyone's time. I might have some follow-up questions, so I was thinking if some attorney can help me in this regard.
Well, like I said, I don't want to put you in the paid consultation area simply because it's not necessary. Nevertheless,
Okay.
you go ahead and shoot off your questions, and we'll probably answer them either in the next follow-up community conference, or whichever way we can. I don't like to charge people for things that I can do free for them. Okay?
Okay. Thank you so much. Last thing I wanted to say was I do not intend to join the job on H1B
You don't have to.
because I already have.
You don't have to. You don't have to.
Okay.
As long as you made yourself available. Look, if you resign, you resigned. It's still illegal for them to charge you for the attorney's fees and for the filing fees. Okay. Now I'll make two guesses here, and I would love to be wrong. Unfortunately, it is probably a company that is involved mostly in staffing and consulting. And the lawyer is probably either in-house or a very small law firm that either doesn't understand the law or doesn't care about the law.
I think they don't care because I talked about to the attorney a couple of times and she's not ready to listen. And
Yeah.
she's like, I cannot put the company at risk. So, I mean, what about when I paid the filing fee? Wasn't the company at risk at that time that you're doing something
Well,
illegal?
not only that, under the law, the filing fees has to be paid by the company. It is the law.
Yeah.
And if a lawyer does not know that, that points to great incompetence in my view. Or
And
it points to complete disregard of the law. You should file a complaint. You can file a complaint in the bar against the lawyer as well.
okay. And so I basically what I told them, give me my approval notice. I might be able to get it transferred to another employer, and they were like, "It's not. You cannot do that because it's H1 is employer specific, and it has to go into effect to do that." Is that true?
That's nonsense. Under the Virginia rules of ethics, I have to give a copy of whatever document the employee asks for, unless I have a waiver in writing that the employee says I choose not to be represented by you. So I can represent only the employer. Even if the employer pays my fees, both of you are my clients with equal dignity. I can't prefer one over the other.
Okay.
Okay. And if a lawyer, it really bothers me when lawyers do that. I hope that is lack of knowledge and not just complete disregard of the law. It just bothers me. I mean, this is just unacceptable. And if you file a complaint against the lawyer as well, you will have no problem, but the lawyer can be in a heap of trouble. Okay?
Okay.
I gotta go.
Okay. So where do I go and look for the form to file the complaint?
Just Google it. It's wage and hour division. I think it's WH4.
WH4. Okay. Thank you so much.
Oh, you're
Rajesh.
welcome.
It really helps me.
You're
Thank
welcome.
you.
You're welcome. Good luck.
Okay.
I have a tweet from somebody who says they have filed a question and their area code. You can just, I see you. I see you. I'll come to you, Mr. Reddy, as soon as I'm done with this raised hand. Okay, Pennsylvania, go ahead. Pennsylvania.
Hi, Rajiv ji. This EB2 September dates got revised, and is there any updates on the lawsuit filed or like what's going on around with that?
Well, I have addressed that issue a couple of times before. In my view, a lawsuit is probably not the right remedy. And I have looked at the complaint. I did not see what actionable claim we did have, which means what can we argue that the court can actually do something for us. I would be very surprised if you are able to get anything out of that lawsuit. I hope I'm wrong. I would love to be wrong. So, keeping that aside for a minute, the way I look at it is you would have been better looking either for a political solution or at least having a conversation with the government if you can. That, what can we, how can we, in fact, one of the things I would have done if I had filed a lawsuit, I would have immediately followed up with a phone call saying, look, we need to talk with your client, which is the government, and we need to understand what is going on. And if we understand what the government has done was unavoidable, we'll take our lawsuit back. Okay, so a lawsuit can be used not just to get justice, but also to get the ear of the government, to get their attention. And really, if something is based upon, and I looked at the response that has been filed by the State Department, I don't know where that lawsuit is going. I don't know what the thinking behind the lawsuit was, but I'm sure there are some good legal minds there. They must have thought it through. I could not make any sense of it. It didn't make any sense to me how a lawsuit would help you in a case where you cannot impute a legal duty upon the government. I also don't see uh, how there can be, again, you are in a very good circuit. Ninth Circuit is actually very pro-immigration, but I don't know where that is going. I would not hold my breath. Okay.
So as a applicant, what can I do on this issue? Like just wait, or like is there any place I can contact and ask
I
for, because I have money
look.
for
I,
bill and a lot of
I
and
personally think I personally think there's not much you can do about
okay, so looks like I need to wait.
it. If anything, I would actually have applauded Obama for doing the best that he could. Remember, instead of suing him, I would have said, look, we appreciate what you are doing because your hands are tied and your legs are tied by Congress. The fault lies at the door of Congress. Okay. Um, can government make regulations? They're making all these regulations and they're getting stuck with them because courts are kind of saying, oh, you are beyond your authority. And some of it is true, some of it is probably debatable. Um, so, I think that the White House, for the first time in many years, has actually tried to do something useful. And I would like to encourage that rather than, litigate against it. That is the way I look at it. Okay.
All right, Rajan, thank you very much.
You're welcome. Good luck. And I have one more question before I come to you, sir, who just tweeted to me. Okay, Wisconsin, go ahead, Wisconsin.
Hello. Actually, I had posted a question that you answered, and I had a follow-up question.
All right, go ahead, please.
Post number 40.
Number 14.
Yeah, 14. Chada.
1 second. What immigration document should I keep?
Yeah. So my follow-up question is,
right.
You mentioned that we should, ideally have a copy of the perm label, which is, are you saying ETA 9089, that one?
That is correct. Yes, sir.
And 140 paperwork. Now, basically, I have a copy of the 140 approval as well as the perm approval, but then my company is not ready to provide me a copy of the perm, like the ETA 9089 and I-140, like the actual paperwork that was filed. So is it like, are they mandated to hand it over to me, at least as a copy, or I will have to accept it and just let it go?
I am not aware of any law that mandates it upon the company, but I know in Virginia, it is a mandate upon the lawyers to provide a copy if we have represented both sides. So I don't know what kind of issues there are, but you have another approach. You can also file a Freedom of Information Act request with both USCIS and the US Department of Labor. See what you can get. Okay?
Okay. So, but you still would recommend to have the perm as well as 140 actual filed paperwork,
No,
right?
I
Not
don't care
just the
about,
approval
I
copy.
don't care so much about the I-140. I care about the PERM 9089 because I want to see how they have defined your job, how they have defined your background experience, so that there is no discrepancy when you do it in the future. Okay?
Okay. Because right now I only have the copies of the approvals for both.
No, I understand that. That's what I told you. File a Freedom of Information Act request. That's the shortest route. Okay?
Okay. Okay. Okay.
Good
I
luck,
think,
sir.
yeah, I got the answer. Thank you, sir.
You're
Thanks for
welcome.
your time.
You're welcome. Okay, guys. Last question of the day. New Jersey, go ahead, please.
Hello, Rajiv ji. Thank you for your time. I had a question about my question number was 11.
11.
I have a follow-up question on that.
Travel when H1 extension is pending, change in I-94 number.
Yes, sir.
Okay, go ahead.
So, what if I don't get my H1 extension that we filed before November 14th? So, can I still stay here in the US because my H1 extension is still?
To the best of my knowledge, yes. I don't see why not. You cannot.
Okay. So.
Yeah, go ahead.
Sorry, go ahead.
No, go ahead. You go ahead. I have nothing else to add.
Okay. My next question is, let's say if I get the approval, H1 approval before November 14th, do I need to leave the country and get my H1 stamped because my I-94 is changed?
No, I-94 change. I-94 change is a non-issue as far as I know. You don't have to do anything abnormal just because the I-94 number has changed. Okay?
Thank you so much, Rajesh.
You're welcome. It looks like we have one more question that has come up. Okay, guys, let's make it the very last one. This one is from California. California, go ahead, please.
Hi, this is Srini. Hi, Raju. How are you?
Good, Srini. How are you?
Good. My question is, I'm currently working as an independent contractor, current employer on TN visa, but another employer provides H1 for myself. I'm luckily.
Okay, your voice is, Srini, your voice is breaking up very badly. This is what I've understood so far. You are on TN as an independent contractor. Another employer has filed for your H1. Am I correct?
Yes.
Okay.
And I got picked on that H1. But I want to continue with my current employer on TN until the end of the year. Then
Okay.
I want transfer to the new employer, but on a TN visa.
Okay.
But I want him to withdraw now. And so once I join an employer, the new employer at TN, and then continue, I want him, he's going to sponsor for my green card. I want to go back to H1 once he completes his permanent labor certification, whenever it is going to take. So is this, everything is legal?
Absolutely. Absolutely. This is what your roadmap is. Okay, let's start with the easy part first. Once your H1 has been approved with a request for change of status, okay, and it is withdrawn after October 1st, you are immune from quota for the next 6 years.
Okay.
So when any employer files for your H1, they can do it without any quota issue.
Okay.
Number 2.
Then,
go ahead.
No, you can continue, sir.
Number 2. The problem that bothers me in this is, if you are on TN and the new employer applied for H1 with a change of status request, then on October 1st, you became an H1 holder, not a TN holder.
Okay.
Therefore, you might have worked inadvertently without proper authorization for the last couple of weeks. Very easy to fix that. Very easy to fix that. Go back to the border, come back on TN again.
Pardon me?
Go back to the border, come back using your TN paperwork again.
Okay.
Now you are back on TN.
Okay.
Okay?
So that means, what if the employer B, he withdraws the application?
Doesn't matter.
The H1.
Doesn't matter. Only thing you need to make sure, the only thing you need to make sure is that they filed your H1 as a change of status.
Okay.
Okay?
Okay. So, so I had to go back to the border and then get back on the TN.
If they have filed it as a change of status. If they have not filed it as a change of status, there are two consequences, probably. The reason I say probably is because you're a little different. If you're a Canadian citizen, laws could be a little topsy-turvy, and maybe you are exempt from the issue of quota, or maybe you are not. Your lawyers will have to look into that. So first thing you really need to look at is, are you a change of status case? If you are a change of status case, go to the border, come back in. You're back on TN. Okay?
Oh, so okay, that means I had to, but okay, so I had to go back and then get in.
That's correct.
Understood.
Good
Okay.
luck.
Thank you.
You're welcome.
Okay.
All right. Bye-bye.
Thank you.
All right, folks. As always, I enjoy talking with you, and I thank you for the opportunity to have a conversation with all of you. I'll see you in 2 weeks. Bye-bye. Every other Thursday at 12:30 p.m. Eastern Standard Time, we host free community conference calls. Everybody is welcome to join. Some people post questions ahead of time. You can take membership in our forums. All of the details are there on our website, immigration.com. You can take membership ahead of time, and it's instantaneous. It happens right away. And post your questions beforehand, or you can just log in. The phone number and all are provided: 202-800-8394, 12:30 Eastern Standard Time, every other Thursday. We have free apps for both Apple iOS platform for your iPhones and iPads, as well as for Android. Just look for immigration.com, the period dot, and the application should show up.